Hello friends, in the series on the income tax cases, today we will discuss a very limited issue that if the intimation or the order under section 143 subsection 1 has been issued by CPC, or whether if the order under section 143 subsection 1 has been passed, whether this order is amenable under section 264, in which the Principal Commissioner of Income Tax has the power to revise the orders which are prejudicial to the interest to the assessee. Generally, section 264 is not adopted by the assessees very frequently because there are limitations that if the revision is done not in favor of the assessee or the revision application of the assessee is rejected, then the assessee do not have the power to file the appeal against those orders. But in the present case, a writ petition was filed before the Bombay High Court to challenge the rejection of 264 application on the ground that it is not amenable under section 143 subsection 1. This matter has been taken by Bombay High Court in the case of GOPAL, Vazirani versus Principal Commissioner of Income Tax and another. And this case has been reported in 466 ITR at page number 376. The date of the judgment is 14th March 2024. In the present case, the assessment year is related to 2011-12, and in the present case, the assessee has sold some shares for a value which has not been received by the assessee fully, and for part of the consideration, a condition was imposed by the buyer of the shares that some part consideration will be deposited in the escrow account and the assessee will be able to withdraw that amount only if there will be no liability on the company after a particular period of time. But the assessee has to file the return of income, so the assessee calculated the capital gain according to the full value of the consideration, including the amount which was deposited in the escrow account. But after filing the return of income and after receiving the intimation under section 143 subsection 1, the liability on the company arose and the buyer did not allow the assessee to withdraw that amount and the buyer withdraw that amount. In the nutshell, the seller was not entitled to receive that part of the sale consideration which was deposited in the escrow account. So the assessee was of the opinion that in the present case the assessee didn't gain that much of the capital gain, so he filed a revision application under section 264 before the Principal Commissioner of Income Tax and recalculated his capital gain. When this application was heard by learned Principal Commissioner of Income Tax, he was of the opinion that section 143 subsection 1 order is not amenable under section 264. So the assessee do not have any option other than going to the writ petition, and when this matter was heard by Honorable Bombay High Court, the Bombay High Court was of the considered view that the order under section 143 subsection 1 is amenable under section 264 and the Principal Commissioner of Income Tax has every power to revise that order. Apart from that, the Bombay High Court said that in the identical facts, the Bombay High Court has decided in favor of the assessee when the seller of the shares was not entitled to receive the part payment which was deposited in the escrow account, which is to be received by the assessee on the fulfillment of some conditions, and when those conditions were not met, the seller was not able to withdraw that amount. So on both technical grounds and on the merit also, the Bombay High Court remanded the matter back to the Principal Commissioner of Income Tax to reconsider the application of the assessee in the light of the facts that the capital gain should be recalculated and the proper refund should be given to the assessee, which the assessee was seeking by filing a revision application under section 264. Friends, this case is very important nowadays because it has been seen that a number of the disallowances and additions are being made through section 143 subsection 1. So the assessee has also this option to file the revision application under section 264. At the end of this video, once again I am repeating the name of the case. The name of the case is GOPAL Vazirani versus Principal Commissioner of Income Tax and another, and this case has been reported in 466 ITR at page number 376, and the matter has been decided by Bombay High Court, and the date of the judgment is 14th March 2024.